have a conversation about the various mandates of the African Commission. What is this Article 59? That's the problem. What is the link between Article 59 and Article 14 that is now in this convention that we are saying is an implementation gap? And that's what we are going to spend a lot of our time discussing. And then we are going to talk about the proposals in terms of what can be done with the law itself for it to be able to meet the requirements for access to justice. And finally, we are going to make a call to civil society formations. And luckily, we are not only joined by civil society formations, it's civil society formations and progressive African Union member states to help us solve this 44-year-old access to justice problem in the accountability mechanisms that we have. We understand access to justice as a cornerstone that lays the foundation for the rule of law. Access to justice allows people to have recourse when their rights have been violated. It does not get more basic than that. And over the years, what we have come to know is that treaty bodies, our constitutions, and various laws have really expanded what this right of access to justice should be and what we should expect when we engage, with accountability mechanisms. Fair trial, we see their guidelines. We talk about a court that is transparent or accountability mechanism. We talk about fair and public hearing. We talk about a speedy trial. We have even coined slogans, justice delayed is justice denied. So May I want to come to you when we start. What exactly does Article 14 of this convention say? So if you can just take us through all the sections, because there are many articles under Article 14. Of course, our focus today is on the implementation and monitoring mechanisms. But just to be comprehensive, what other provisions are there, in the article? So let's just start there.
Okay, all right. Okay, so Article 14 of the AU Convention on Ending Violence Against Women and Girls, it sets out the implementation, right, and oversight framework for the convention. And it has 4 subsections. The first, it provides that state parties shall ensure the implementation of this convention and shall include in their periodic reports to the African Commission on Human People's Rights, as required under Article 62 of the African Charter on Human People's Rights, the legislative and other measures undertaken to end forms of violence, all forms of violence against women and girls. Subsection 2 provide that in the implementation of this convention, the African Commission on Human and People's Rights shall have the mandate to interpret the provisions of the convention in accordance with the African Charter on Human and People's Rights. The third subsection provides that the African Commission on Human and People's Rights may refer matters of interpretation and enforcement on any dispute arising from the application or implementation of this convention to the African Court on Human and People's Rights. And finally, subsection 4 states that where applicable, the African Court on Human and People's Rights shall have the mandate to hear disputes arising from the application and or implementation of the convention. So this is word to word what Article 14 of the CEVAWG Convention states.
So for many people, this would sound like there are just so many ways, for people to implement the convention. You can go to the African Court. The African Commission can refer cases to the African Court. and the African Court can implement and monitor, because that's what is written here. But for someone like you who do work at the African Commission, what do these things actually mean in practice and with your expertise?
Okay, so the first thing is for us to understand that based on Article 14, the mandate to implement and monitor the convention is bestowed with the African Commission on Human People's Rights, which includes interpretation, implementation, oversight, and dispute resolution. Okay, now coming to unpack it. The provisions, for example, Article 14.3, entrust the African Commission to refer cases to the African Court, for example. However, the Commission in over 2 decades has only referred one case, the Ogig versus Kenya case, to the African Court. So this mandate is not really practiced. And it also undermines the principle of complementarity as stated in Article 5.1 and Article 5.3 of the Protocol of the African Court, which allows the Commission to refer matters and communications to the African Court directly to deal with it. And then when we look at 14.4, subsection 4, that while the court it has the ability to hear disputes under the convention, this is conditioned on state making the declaration, right? The famous declaration under Article 34.6, of the protocol, by which states accept the competence of the court to receive cases from individuals and NGOs. The problem here is that many states have either never made this declaration or have withdrawn it. 10 countries in total have made the declaration under Article 34.6 of the protocol, which allows, like I said, individuals and NGOs to approach the court and bring directly cases to the court. And it also governs the referral process. The state has to have made the declaration. From these 10 countries, we have Burkina Faso, Cote d'Ivoire, Ghana, Malawi, Mali, Rwanda, Tanzania, Tunisia, and Benin, and Gambia. 4 of them have already withdrawn. Cote d'Ivoire in 2020 have withdrawn the declaration. Tanzania in 2019 withdrawn the declaration. Benin has withdrawn the declaration, and Rwanda withdrawn the declaration in 2016. So it kind of gives you an image of the ability of the court to really adjudicate matters, communications. And it really undermines, the utility of the African Court as an accountability mechanism under this convention. We only have 6 countries that have made the declaration all across the continent. So this is a problem. So yes, when you look at the Article 14, you'll see yes, we have avenues here and there, but there's problems in each avenue that is mentioned.
Okay.
Yeah.
So what you are telling us is that Article 14, before we even get to the designation of the African Commission as an implementation and monitoring body, is that the other provisions are really a reinstatement of existing problems that have not been solved.
Absolutely.
And so it's basically moving problems that the protocol that establishes the African Court have, that states acquire, give jurisdiction to the court by depositing this Article 34.6. And now we are sitting about, I think it's 6 or 7 of them that have accepted the jurisdiction of the court, and with the others having left. And that this provision of the African Commission referring cases to the court is also something that the African Commission actually has not done. And we still don't have a solution to that problem. So these other sections that are sitting there on Article 14 as part of the implementation and monitoring framework are basically a reinstatement of the African, of existing problems.
Yeah.
But we have problems with these, and we have bigger problems with the African Commission being designated as the implementing and monitoring mechanism. Why is this a problem? Why is it that we kind of have formed this view that it constitutes an implementation gap. What is the harm?
Okay. The overarching harm, or why this designation is problematic, it literally leads us to, our campaign, Article 59.1, where Article 59.1 of the African Charter, right, that governs the confidentiality and access to information when it comes to the measures that have been adopted by the African Commission on Human People's Rights, and the problems that really arise from how the African Commission interprets this article, meaning that there's a blanket confidentiality to every and any procedure that relates to communications that are brought before the African Commission. So let me just go back a step and say what Article 59.1 says, word to word, as it's reflected in the African Charter. Article 59.1, it states that all measures taken within the provisions of the present charter, within the provisions of the present chapter, which is chapter 3 of the African Charter, shall remain confidential until such time as the Assembly of Heads of States and Governments shall otherwise decide. Subsection 2 states that, however, the report shall be published by the chairman of the Commission upon the decision of the Assembly of Heads of States and Governments. And subsection 3 states that the report of activities of the Commission shall be published by its chairman after it has been considered by the Assembly of Heads of States and Government. There's a lot of consideration, there's a lot of things going to the Assembly of Heads of States from this article. But going back to subsection 1, when it says all measures taken within the provisions of the present chapter, within chapter 3, there's a provision of communications procedure, basically, before the African Commission. And the way that the African Commission has interpreted this article, the word measures, it has adopted an interpretation that requires a blanket confidentiality over everything, really, whether it's adopted decisions, pleadings, communications, until they're officially considered. And within our conversation, we'll come to this, considered by the African Union Assembly. So basically, this interpretation and this blanket confidentiality results really in significant consequences for access to justice, transparency, civil society engagement, access to information, public and fair trial, and overall access to justice really to victims. Civil society organizations and litigants are unable to access information regarding pending communications, and they're really not even able to engage in advocacy when it comes to the communications. So let me stop here, but I'm pretty sure we'll unpack it deeply within our conversation. But yeah, it's a very problematic article, yeah.
So that's the literal interpretation, right, that has been given to this provision. And there has been attempts, and we'll get to this, to engage the African Commission to say you have to take a progressive kind of interpretation of this provision, because this Article 59 is really an anomaly, when it comes to accountability mechanisms. That we have seen that globally, comparable mechanisms do not have this provision. Even the new mechanisms that have been set up on the continent, the African Court, the Committee on the Rights and Welfare of the Child, do not have this, because it is a barrier of access, to justice. Now, I think what is important is just for people to really understand what it does, like in practice. When you say everything is confidential, the way that they have taken it, it's that as litigators, we actually cannot publish our own pleadings because they have interpreted the measure under Article 59.1 to include everything that goes to the commission, then it just becomes a secret. Like you cannot tell anyone, you can't issue a press statement, you cannot post it on your website. So that's the one thing, it's about the scope, because the provision of the charter says measure, and how can our pleadings, the complaint, the story of the victim of what happened to her become a measure that is confidential. That the African Commission silences the victim from speaking about violations that happened to them, and also that they have taken this step of referring this to the African Commission. And over years, there have been no public hearings. And I remember when I started working at the African Commission in 2007, most of us who litigate, we would come late at the end of the session. I remember we were in Ghana when I joined, May of 2007. In 2008, we went to Eswatini, and we will stay as litigators to wait for the private session of the commission in order to argue our cases. But right now, we don't have hearings anymore. This is where we have landed, because once again, it is confidential, or it could be for another reason, but it stopped. So even the most recent decision that we had, everything was argued on paper.
Yeah.
So the right to a public hearing does not exist anymore. The other thing, the third one, is that there is no cause list that is published. Anyone who works before a domestic court or anywhere, you can see the cases that are pending, before the mechanism. That these are the cases, this is the case, this is the state, and these are the kinds of violations that you actually have. Like this country struggles with racial discrimination because you see most of the cases. But researchers cannot actually talk about this because they actually don't have this information. So it's become harder to talk about the state of human rights violations on the continent because you don't have something as basic as a cause list that tells us what's happening. This bar from communication for people like us who do public interest litigation is a big problem, because we understand that what happens outside of the courtroom is just as important as what happens inside the courtroom. That for us, impact is not really what happens on the day of the decision, that we are able to communicate about our cases at different intervals. And you can begin to see institutional reforms because states actually don't want to be embarrassed.
To be called out, yeah.
Yes, so whatever it is that we have taken them there, they begin to change even before the decision. We had a number of cases at the time before the court got to this, the commission got to this level of confidentiality, that once we had filed, then they would say we no longer have that provision, in the law. So this interpretation has now really limited what is possible when we litigate. The public narrative, that a case can help to reframe kind of public narratives. That a case can help to shift, like the institutional reforms that we are asking for, because they change the law, they start engaging with whether the judiciary or the police or whatever body that has contributed to the violations that have been taken there. So you don't have this because you are barred from communicating and barred from doing any advocacy about your case because everything is a secret. The rules of procedure of the African Commission allow us to join in other people's cases, provide expertise as amicus curiae. So there is a procedure that is there in the rules of procedure of the African Commission, but you cannot intervene as an amicus because you do not know the cases that are pending there. So even with our friends, we can't actually tell them that there is a case that's pending and you can come and join and provide expertise because we are barred from sharing this information. And you would think that's the worst part of this. Then there is a delay in the transmission of the decisions. Of course, this is becoming kind of contentious, and I think we should just lay it because it came up on Tuesday at the Pan-African Parliament when the vice chair of the commission was there. And in her response, she said that they do not publish the decisions because that's what's prohibited in the charter, but they transmit them immediately until adoption.
Is that accurate?
Of course, it's either she misled the parliament or she does not understand how the communications procedure works. Because we had a communication before the African Commission, and in March of 2024, we received notification that the Commission has adopted this communication. And then we waited for the adoption by
the Assembly.
Which is now the Executive Council. And we only wrote to them in March to say, hey, the summit has ended. So what we want you to do is to transmit the decision. The legal officer in charge of communications wrote back and said, no, you cannot have the decision because we are waiting for the Executive Council to publish its report that confirms that the activity report of the African Commission has been adopted. We received the decision on the 20th of June 2025, 15 months after it's been adopted.
It's been adopted, yeah.
And they didn't just do this to us. I was talking to colleagues at Equality Now who have a case against Congo that refers to another decision that they have not received, but it's already referenced in this case that they have received. The case against Nigeria on obstetric violence.
Maternity health, yeah.
Yeah, that case was decided in 2023, in the middle of that year, and was only transmitted to the parties in 2024.
I think around May or thereabout, right? Yeah.
IHRDA, so the organizations that we work with, they have decisions that have been waiting for from 2023, from 2024. This is an ongoing conversation. This is an issue that has been raised with the African Commission that they know about. And so this is the system, right, that we are kind of dealing with, that this is what it means to take this new convention and consign it to the African Commission, because that's what the African Commission actually does with communications. Now, where I want us to go now is, why do you think we have not been able to do this? So what are the implications of CEVAWG, of this convention and access to justice? And yeah, what is it that we are actually grappling with here? Because for anyone listening, it's that this is a violation of rights. In fact, lawyers who are attending this webinar are thinking, if you were to take any country that does this to the African Commission, they will say that they have violated rights. So where does this actually take us?
Okay. So I think you've laid the ground really well when you've mentioned the implications. Article 12 of the CEVAWG, and CEVAWG is the convention, right? The abbreviation, yeah? Talks about access to justice. And here, in this instance, we're talking about access to justice to women and girls who have been subjected to different forms of violence. But then, having the commission to be the one that is responsible for the deliverance of this justice, given the pre-existing, challenges that it faces, it's going to be, we will be in a rabbit hole, honestly, with the new convention. And just like you said, as litigants and activists, civil society organizations, we have all these obstacles in engaging in communications. But when we look at it from an international law perspective, we see that this practice that is based on this interpretation really violates, a set of rights that are guaranteed in international conventions, right? Human rights conventions. Access to justice, and just like we said, access to justice delayed is access to justice, or justice denied, right? Something along these lines, yeah. And it really, the overall, delay in access to justice will also impact the confidence of the public when it comes to the mechanism. And at the same time, when it comes to the right of fair and public hearing, as reflected in, the African Charter and the ICCPR, we don't have public hearings anymore. For some reason, they just stopped. When it comes to access to information, nothing. Everything is confidential. When it comes to freedom of expression, this one is very interesting because in some instances, we have litigants that have been asked to withdraw information that they've shared on their websites around, communications that they have pending before the commission. And ultimately, when it comes to the overall implication, this kind of impacts the right to an effective remedy, which is also provided for under the African Charter and the ICCPR. I think what I also want to just say that when it comes to, the freedom of expression and how, as litigators, we have been, our ability to kind of share information about our pleadings, etc., has been taken away from us. The problem that we also see when engaging with commissioners, for example, is that we are getting conflicting feedback around this issue. Some of them are saying, no, you can actually share. But then when you engage at a later point, it's completely different. Oh, that was just a personal opinion of so-and-so commissioner. So I think aside from the public and the victims, we ourselves are also kind of confused because there's conflicting information and there's lack of information. So if we proceed with CEVAWG being, supervised, or the implementation of it under the African Commission, we are at risk of facing the same issues again. And then also when it comes to victims of violence, this means that there's going to be some sort of continued invisibility, right? Until these barriers are addressed, honestly, through either reinterpretation, reform, or structural design, entrusting the African Commission with this responsibility to implement the convention will only kind of reproduce the same existing failures and challenges that we've been facing. Yeah.
In the Article 59 campaign, that is really pushing for a progressive interpretation of the African Charter, one of the things that we have heard from the commissioners, because last year the campaign really had a public session in October with commissioners present to have a conversation about how to resolve this. And one of the offerings that were made by civil society is that there is Article 60 that really says when interpreting this charter, you can be inspired. But what's happening in other systems like international human rights standards and all of that. So really saying this is a living document.
Yes.
You don't have to sit with things that don't make sense. And we have seen them kind of do this, interpret the African Charter in ways that takes into account, like having it infused by
what's happening in the world, basically. Yes.
what has been the Commission's position on this issue? Like, why is it that they are not using Article 60 in order to develop, Article 59? They're just right there next to each other.
Okay, so the thing is, in several engagements that we've had with the Commission, specifically the commissioners around why not adopting, a more progressive interpretation for Article 59, for Article 59 as a whole, basically, with a specific focus on Article 59.1. Because like you said, you already have Article 60 over there that tells you that you have the ability to draw inspiration from what's happening in the world, the internationally accepted standards. Upon several engagement, in several instances, we have commissioners that have been saying that we are bound by the text of the Charter. Who are we to do otherwise? We compare like with like. And this comparing like with like have been said to us multiple times when we try to shed light, and highlight the fact that it's abnormal what's happening with the Commission. When you look at the practice in the two other sister bodies, the African Court and the African Committee of Experts, everything is done in the open. Everything, there's access to information, decisions are shared instantly. But then we're told that we need to compare like with like. You cannot compare orange and an apple. Yeah.
So I think for me, whenever I hear this or when I see it, it's like the African Commission is not fighting for us, for African citizens, because we are sitting there with mandate holders. Like, this is the body that is tasked with the protection and promotion of human rights in Africa. And what is scary is the alignment, because you would expect them to say, this undermines our independence. We have seen it, before domestic courts. We have seen, like, the judiciary and quasi-judicial mechanism basically saying this is a barrier, to me doing my work. Because even Article 59.3, we tried with the Center for Human Rights at some point to go to the African Court to say, what is the meaning of to consider? So we can't do anything because member states must consider. But how does a human rights body wait to do anything before the consideration of a political body, the body that you are set up, to monitor and to ensure that they do not violate, human rights? Why would this not be something that actually enrage the Commission, itself, to say, we can't have this. And in 2006, there was an attempt by that Commission to interpret Article 59, and it was completely under different circumstances.
And different commissioners sitting there.
Yes. But here we are now, because at the time, we would at least receive the decisions as parties. They will tell us it's confidential, but the victim would know that they have reached and say, we will publish after we have shared it, but you need to know that you have actually won this case or whether you have lost this case. I want us to go to what civil society has actually tried, to do. I've talked about the campaign, but what are the various efforts? Because I think there is a convention now, the conversation where people are saying all of these slogans and chants that we are hearing when people are speaking about this convention. We didn't get everything that we want. You must see the glass as half full. The Maputo Protocol was a shield, now we have a sword. And we can always fix things later, right? So can you tell us what has been done, to fix this Article 59 that comes from the 1981 Charter? And what is the meaning of saying you will fix
later
the CEVAWG later, when it's actually been taken to the problem that we have not been able to fix, because the commission was established in 1987. And so here we are sitting 38 years later, unable to solve this problem. And people are saying, you need to go there because that's the best that the African Union can do for us. So what have people tried to do to fix the problem?
Okay, I think to start answering this question, like you've said, we have been facing this challenge for decades and decades, and it hasn't been solved. So it really brings up the question of, on what basis are we saying that, you know, these issues that we have with the CEVAWG Convention will be resolved later? Let's just concede that this is what we have, this is the best we can get, everything else we'll resolve it later. Considering the lack of political will that keeps on, you know, with every set of new commissioners, there's also lack of political will because it is an extension of, you know, what member states want, which kind of takes us to the whole issue of independence and Decision 1016. But this is not the subject of conversation for today. Going into what civil society organizations have been doing to engage with these challenges, I think I'll start with, you know, the litigants group, basically. It's a group of civil society organizations, litigators, activists that have been engaging with the African Commission for over 15 years or so, with the overall objective of strengthening the protective mandate of the African Commission. And yeah, the engagement has been constant through the litigants group. It's actually under the litigants group umbrella, the Article 59.1 campaign was born, where the litigants group have been identifying issues that affect, you know, the communications procedure, and they've been engaging with the Commission through requests of advisory opinions, campaigns, or leading even roundtable discussions, etc. So just connecting it with Article 59.1, you've already kind of introduced Article 59.1 as a, you know, a collective initiative that is coordinated by the litigants group, but it also involves a broad membership of civil society organizations that are really struggling when it comes to engaging with the African Commission through the communications procedure. And yeah, the Article 59.1 campaign overall objective is to advocate for a more progressive interpretation of Article 59.1 and the confidentiality, blanket confidentiality practice of the African Commission. There's also CEVAWG, the Coalition for Independence of the African Commission. It's also a collective of civil society organizations who seek to protect and defend the independence of the African Commission, with efforts that are based on the premises that, you know, both the regional and international human rights bodies, as well as civil society organizations, they play an essential role in holding states accountable. So if we have a body that is compromised, then everything that we're doing will be in vain, really. You will not be able to hold member states accountable for their human rights violations. And then one of the recent campaigns that is led by one of our partners, RFK, Robert F. Kennedy Human Rights, is the Arusha Initiative, which also really connects to what we're talking about here. It was established in 2023, and it is a result of a concerted civil society effort and concern to enhance the efficiency of the African human rights system mechanisms, as well as responding to the attempts to weaken their mandate through making sure that we have a say in the nomination, election of those who sit in these bodies, to make sure that we really have Africa's best sitting in these mechanisms, which would result, like, you know, the impact of this we can see, we will be able to see it in the decisions, in the practices, in the engagement that they have with African citizens. So it's been a lot of efforts here and there. There's definitely resistance due to the lack of political will. Yeah, let me stop here with this point here.
You know, one of the things is this convention was adopted in February of 2025. Mm-hmm. And Article 59 was in conversation with the African Commission, and this happened in front of member states, that there is a challenge with Article 59 and access to justice. This is happening almost parallel around the time of the negotiation of this convention.
Yeah.
So it is adopted while the issue of Article 59 is live. So there is not one person, the African Commission, who can say, when we were asked, because now the language is, the African Union, in its wisdom, saw it fit to give us this implementation and monitoring. Why did the African Commission not resist? You know, if the African Commission wants to protect our rights and say, actually, we cannot take on this because as a body that has to do implementation, we are compromised. There is this article we already have to implement and monitor the charter, and this is how people who litigate before us, victims of rights violations, are shortchanged. This is how they cannot access justice. Do you know if any of these conversations actually happen around the time that the African Union decided, you know, to entrust, you know, this? You know, because there has to be something around good faith, right? Because that's what we know about treaties, that even when member states ratify, you have to do this in good faith. Why would the problem that is known in the African human rights system actually be allowed to persist and be entrenched by saying, here's another convention, take it to that body that is dealing with access to justice? Do you have a sense of what was going in there? Is there a way for us to know how these decisions were actually made to give this implementation and monitoring to the African Commission?
Okay, you've asked a difficult question, because the same issue around access to information that we've been facing with the practice of the African Commission seems to be, that's going to be the way to go with the CEVAWG Convention as well. It's not just us, like at ISLA, right? A lot of other civil society organizations that, and feminist organizations, women rights organizations, when the convention was in the drafting stage, they were not consulted. There wasn't any form of open communication around the stages. Okay, we've reached this stage. We haven't. We have this proposal. We've been hearing things that the implementation and monitoring would be given to a specialized body, for example. But again, hearing but not really knowing, because there's no concrete information that is provided. And at the same time, when the convention has been adopted, the preparatory works is also missing, which is in clear violation, right, of Article 32 of the Vienna Convention on the Law of Treaties. If we had this preparatory work document, it would kind of help us in understanding the convention, the context that it was developed in, the conversations that led to choosing the African Commission to be the monitoring body for this convention. So there's a lot of, the whole process has been opaque. We are not quite sure as to how we landed with the African Commission to be the monitoring and implementing body of this convention, given the pre-existing concerns that we have voiced out over and over again, to the extent that I feel like whenever they see us coming, there's always that energy, you know. These people have come again with their Article 59.1. But then again, if we are persisting and we're talking about it and we are providing you with comparative analysis documents just to show that it does not make sense, then why not revisit this position within the mandate of Article 60? So just to answer your question, there's no clarity. We really don't know what were the conversations that led to the African Commission being the body that is responsible for the convention. Yeah.
What I have heard, because I haven't read this, is that what was raised was that the African Union has a moratorium on the establishment of new mechanisms or new institutions, right? And so also what came out during the parliament this week was that they decided,
the Pan-African Parliament.
Yes, that it's better not to duplicate. So the African Commission, if there's another body, then it's a duplication. So it could be any reason, but one is that there is a moratorium, but also another one that has been placed on record at the Pan-African Parliament this week is that developing an implementation mechanism within the convention would then lead to a duplication of efforts. So that we're just going to have to find out. You know, one day when someone decides that we are worthy of a travail préparatoire that explains to us and helps to interpret, then that's when we will know how that decision was actually made. But the reason why I'm asking this is it would help us to understand whether there is a plan to fix this problem. You know that, let's give it to the African Commission because we will fix this problem. We are aware that there is a problem. Because part of the anxiety about going forward, campaigning for ratifications is we know the price of trying to have this conversation with the Commission about Article 59 and its impact of access to justice. The victim that I am talking about, our client, it was an awful case, trafficking against Namibia. And we are sitting here now with a client that she didn't believe us when we called her last month and we said, actually, your case was successful. Because she said, I thought you were just embarrassed to tell me that I lost because you told me that a decision had been adopted and then I had to wait all of these 15 months, in order to get this kind of decisions. And so for me is part of what we are struggling with is when you look at this as a legal instrument, when you look at the efforts, because legal academics have been writing about this, as legal activists, we have also been writing about this as practitioners to say, we are struggling. And I sometimes get the sense that the Commission has actually given up on the communications mechanism because they still do a lot of work that is meaningful with the promotional mechanism, but it is this one where we don't seem, to be moving, and that's why I think it's become important to us to raise an alarm, to actually say all is not good, because I think for many people this is the first time that they are hearing that there are these provisions, these challenges at the African Commission, because it's things that are known by us who work at the African Commission, and so because that's where we work. And so other people come and do other things, and they may find the space useful, like people are able to develop general comments, and because of the nature of our work, we have to celebrate the successes, and we take no pride in being the bearer of bad news. We also want to have a new convention where we actually go out, to celebrate. But we have decided to take this unusual stance on a new convention because domestically, yes, we have these meetings and actually say, we saw this coming. If they pass this legislation with these problems, that's what we are going to do. We are going to take it to the Constitutional Court. We are going to challenge it. But the challenge with this convention is we were not afforded an opportunity, to engage. So the same secrecy that was there, it's the same secrecy that happened in this. Many organizations that we speak to say, I heard that they have adopted a convention. I didn't even know that one was under development. So let's try and wrap up so that people can ask questions.
Yeah.
What is our call to action to civil society? Because, of course, we have taken this position of being the bearer of bad news. What's our good news?
Okay, so basically, we don't want to just state a problem and leave it there. some of the proposals that we have been thinking about into addressing the implementation gap that we have seen in this convention is to continue advocating for a progressive interpretation of Article 59, which using Article 60, right? But then again, this proposal would require willingness from the African Commission to really sit and see the problem. And also maybe refer to the 2006 president where, like you mentioned, they were more, when they were more like open and functional interpretation of Article 59.1 that was attempted at that point.
Okay, let me just stop you there like a bit. The difference between 2006, right? Because the conditions in 2006, so let alone who was in the commission who was able to do this interpretation. What are the factors that have made a progressive interpretation of Article 59, possible from the AU itself? So when we say you can do this, you can interpret Article 59 to remove this abnormality, what are some of the things that have changed?
Okay, one of them brings us back to decision 1016, right? Because that was an obvious interference with the independence of the commission, where they're sitting as a monitoring body of the human rights records, let's say, and practices of African human rights. No, I mean the member states was really kind of taken from them. It's like, no, you will listen to what we say. You are an extension of us. And from 1016 up till now, you kind of like see this kind of understanding of the commission is an extension of member states. And therefore, when member states are not willing to kind of have everything in the open, the commission, unfortunately, will adopt the same position. And in several instances, again, we have been hearing from commissioners language of rights of member states. So it is an extension of problem that relates to independence of the commission, as well as the caliber of the commissioners that we have sitting there, which are to a large extent political appointees. Yeah.
So there are two things I think for me that I think can also kind of add to the progressive interpretation issue. One is obviously that the activity report of the chair of the African Commission was usually submitted twice a year, during the mid-year summit, June, July, and then in the beginning of the year, January, February.
Yeah.
It's the African Union itself that said you must only report once. And I think that should give them a basis to say, this is justice delayed. Let us just share these decisions, with them, because it's you now who has extended, the time. So it gives them more arguments, if they want to fight for access to justice.
Yeah.
But the second one is really that the African Commission, and I think for me, when we had that public session, I don't chew mirrors, but I just felt like nails and mirrors will be okay right now. When the former chair of the African Commission told us, and it was because I think it was Michael Nyako from IHRDA who had raised this and said it is unfair that member states get to see the decisions and the victims don't have them. And the commissioner said, actually, they also don't see these decisions because we do not send these decisions to the African Union. We send an activity report, and the African Union, it was them that also adopted a decision that said, your activity report must be 10 pages. So this whole story about Article 59, it's basically a game. It means nothing to anyone. Member states under Article 59.3 have to consider these measures that have been adopted. And then the chair can publish under Article 59.2 after this consideration. And under Article 59.1, the measures are confidential, pending, unless member states decide otherwise. If the member states do not consider the measures under Article 59.3, right? Because the confidentiality from 59.1 goes all the way to Article 59.3, they don't even see these measures to consider them. What is the point of Article 59.3 other than
giving us headache? Giving us headache.
Yeah, exactly. Because it's basically the African Commission observes symbolic consideration by waiting for the date of the summit to pass. And then they consider this consideration. And they still have the audacity to write to us and say, we are waiting for the African Union to write a report that says they have adopted our activity report, which they know does not have these cases.
Okay.
So a progressive commission can actually say it's time for Article 60 now. Because this measure has become obsolete.
Yeah.
We kept confidentiality because you told us you wanted to consider the measures, but you actually told us that you don't need to see these measures. And therefore, we have no reason to inconvenience victims that come before us. And this is what has not happened. So for me, when I think about the 2006 interpretation by that commission, is that maybe if we had that commission in 2025, they would now be jumping up and down to actually say, this is the time to actually lay Article 59 to rest. What else can we do?
Yeah, because I think from what I'm getting from what you said, that this consideration, it's literally impossible with the limitation of the report. And I'm guessing the report will just have so-and-so versus this date. That's it. Okay, okay.
So what other things can be done? So that's number 59, Article 59. The African Commission can do this using Article 60. And I have formed the view that is a lack of a political will, not because the law, that is a legal barrier to kind of doing this. There are so many arguments we have given them. They just don't want to use them.
Yeah, and we can't really say that it is what it is. This is what the Charter says. This literal interpretation does not make sense, for people who understand the law. I think the second or the third option or proposal that we've been thinking about is to assign limited jurisdiction to the African Court, where we propose that the African Court can be granted limited and direct jurisdiction over CEVAWG-related cases. There has to be a requirement to bypass the requirement of Article 34.6, which currently, also constitutes a problem when it comes to engaging with the African Court. However, when you look at it from the other side, interacting with the African Court on CEVAWG-related cases would ensure that there's openness, and that once a decision is reached, it's adopted, it's communicated, justice is served there and then. And then I think we also need to kind of draw from comparative regional practices to see how this approach is visible or not, which means that we need time to really analyze and unpack the proposal that we have before we push for ratification. Because pushing for ratification is really shooting ourselves in the leg.
I mean, this is a new kind of a thing, right, that we have started toying around with this idea of limited jurisdiction, because it may have its own challenges, and that's why we are asking for time, right, to consult broadly with other people in the sector, because this thing was only published in June last month, right? Because this convention, not this thing, because we don't want to undermine the campaign for ratification for 34.6. And we want African women and girls to have access to justice. But this is not only a problem for African women and girls. Everyone else who's subjected to Article 59 has the same challenge.
That's right.
So where we need to kind of go back to, so we would need to be clear, about how we take that forward by looking at the pros and cons and then actually agreeing that maybe it helps us. Because if only a handful of them have accepted the jurisdiction of the court, then what does it mean, for the court? But also, what does it mean if we say to member states, you can pick and choose the conventions, the human rights that you want to be held accountable for, and all of that. And then there's a third one.
Okay.
The third one being the Vienna Convention of the Law of Treaties.
Yeah, the Law of Treaties, yes.
Because in the Vienna Convention, you have Article 44, which talks about severance.
Yes.
And there are conditions that allow you can sever a provision of a treaty
that no longer serves its purpose.
Yes.
Or contradicts with the object and purpose of the overall treaty. In our instance, is the African Charter. Yeah.
So there are all of these things. The African Union, if it wants to fix this problem, it can fix it. The African Commission, if it wants to fix this problem, it can fix it. So it's up to them, because we don't have the powers that they have to do this. What can we do as civil society? And then we open as questions. What are we asking from civil society going forward?
Okay, so when it comes to civil society engagement with the convention, the CEVAWG convention, one of the things that it's not just us. So far, with the limited engagement that we've had with other civil society organizations that are concerned, we find ourselves sharing the same concern that we were not on the table really when this happened, when the drafting happened, when the conceptualization happened. So at least what we need is time to really unpack the convention and conduct deeper analysis. Yes, at ISLA we are concerned with Article 14 because what we do is we litigate, and our engagement with the convention would be impacted directly. But other organizations have also shown concern in different areas. They want some time to analyze the gaps, to see what are the value add really of the convention, given that we have the Maputo Protocol, and also looking at the lessons learned from the Maputo Protocol that we can use and we can benefit from when it comes to this convention. And then this would help us to really envision a broader strategy of how we can move forward with this convention. But it would be unwise to move straight up to ratification of the convention without allowing us the time to really unpack it.
So yes, we need to unpack. So what we are asking for is, let's pause the ratification campaign, analyze the convention, have an outcome on whether we've got more gains, gaps, and then what it is that can be done to fix it.
Yeah.
Because we feel that African women and girls deserve better than chants, slogans, and catchphrases. So if we are saying we are going to fix it, we have to ask, is it fixable? And more importantly, who does it and who leads it? Because part of this is, if this convention is really not worth the paper that it's written on, then we should not be distracting people who are doing work to respond to violence meaningfully by giving them pieces of paper and then celebrating them, So let us form a view. It may well be that Article 14, when people look at it, is a small thing. Like, there are other things that are very great in the convention, and people collectively decide, let us go and we will see what we do with access to justice. We came in first because we wanted to sound an alarm about something that bothers us tremendously, because for us as litigators, it was, here we go again. They are taking us back to the place of harm, of hurt, of violence. So this is what we are asking of civil society. Pause. Who are the stakeholders that we say they must engage with? What are we asking here?
Okay. In terms of engaging with key stakeholders, we are looking into engaging with actors that have been leading or influencing, the ratification process, such as the AU Special Envoy on Women, Peace and Security, Office of the Legal Counsel, of the AU Legal Counsel, the Special Rapporteur on the rights of women and women in Africa, even though, yes, we acknowledge that she is currently rotating Africa in pushing for campaigns. But it's really important that we sound an alarm, like you've said, and we make it clear that we have our concerns, that we are not moving forward with this convention the way it is, without really having the time to sit and analyze and think, where are we headed really? Is it taking us backward? Or, and then it's also important to engage with UN Women. They've been leading in really convening, the convention, the ratification, etc., as well as, engaging with national and regional civil society organizations. Importantly, the ones who work on the ground, the ones who really engage with these issues, either at the national or regional level. Once we make sure that we engage with them, we need to also ensure that the stakeholders kind of like share their own independent assessments of the convention, and also look into the several proposals that we have, and then collectively, like you've said, we are able to decide where we are headed. Either, yes, we continue with ratification, but knowing where are the gaps areas, where is the value add, and how are we going to address these gaps, or we pause the ratification process and we take it backwards to them. Yeah.
So thank you very much for listening to us, and this is the time for you to ask us questions. More than anything else, we have an agenda. That's why we called this meeting. We are not going to shy away from that. Our agenda is the protection of women and girls from violence in Africa. And we hope that you will join us if that's what you are fighting for. And we hope that this has clarified what the challenges are. Yes, I see a question from Dr. Faye on Zoom, but I think there are other platforms, so there would be other questions, so our colleagues are going to help us. Dr. Faye, please come.
I would like to say the organizers of this discussion, and I was really very fast. But first of all, when I informed that was on Article 14, but then I came to understand that there have been a lot that have been said, a lot of things that have been analyzed around Article 14. I think that the problem of this debate sessions is about to think from the new convention of the African Union concerning the elimination of the violence, and that this we should think on the implementation from Article 14. But now, I think Article 14 seems to be a standard article that we can find in all the conventions related to the human rights in Africa. So this is an article which has 3 sub-sections, and this is an article that should be associated not only with the Article 62 of the chapter, but also Article 26 of Maputo on the presentation of reports. So, whenever we talk about implementation or we talk about application, and here I would like to say that there are 3 steps which are very important. So I would like to say, with this new convention, we have to work, first of all, on the ratification of this convention, because for the implementation of what you, meaning we should know at which time victims could access their rights. So we should engage first in advocacy on the ratification of this convention. So this is very important, because we know that presently there are only few states that have moved toward the signature. So in May, I think some countries will start, but I can name them. We have Djibouti, we have Liberia, we have Angola, we have DRC and Gambia. But it's not only the signature, but there must be commitment. So we have to work on the ratification, and after this, then we will be able then to think about the implementation. So first of all, countries and states should be forced to present the report, and you have said this. So we have to know what are then the national measures that have been taken by states to make sure that there is an implementation of this convention. That is the first element. And secondly, the Article 14 by itself stipulates that it is the African Commission which has the mandate of the interpretation in conformity with the Article 45 on the right of people, and it has the mandate of protection and interpretation, not only of the Charter, but we will understand here about the African Commission has also the mandate to interpret as the instruments all the protocols that are additional to the Charter.
That's fine.
So
She's making the
we
point.
should not forget this. So the African Commission has this responsibility. So I would like to notify that here I'm a commissioner, and I have the freedom to intervene and talk. So when we say that the African Commission will interpret this convention, I think this is very important. And you have linked the interpretation with the Article 59. But these are two different steps. So the Commission can introduce different interpretation of the Charter or interpretation of the Convention if then there is no clarity. But you have to understand that from Article 14, I have seen that you have established a bridge with Article 59 and Article 7 of the Charter. So I would like to finish with Article 14, saying that the Commission has the possibility of interpretation of this convention and also to its execution. So when there is a problem, I would like to come now to the Charter. We have two types of problems. We have individual complaints. These complaints are different and are linked to different types of violences. So these ones, these individual complaints take a lot of time because they are on the Commission's responsibility. But your problem, if they link with Article 59 and confidentiality, I think we should treat this separately. We are talking about the right to access, and we are talking about interpretation, and we are talking about confidentiality. So I think these are three problems. So the problem of the Article 59, this is a point that we get in the procedures which are engaged by the African Commission in relation to what I can call the mandate of protections when it comes to different communication. So whenever we come to Article 59, and when it is said that all the measures that are taken in the previous chapters are confidential, this confidentiality, and you have explained this, it is the confidentiality of all the communications that have been adopted by the African Commission after the process to what I can call to the definitive decision or to the final decision. So this is confidential. So the African Commission cannot publish the decisions that it has taken until the activity report of the Commission is validated and adopted by Executive Council. So this is a debate that we have already had to the African Commission when I was there. So it seems impossible to me to understand that a communication that has been adopted in 2025 should not figure in the report of activities that will be presented in 2026, because I think the report of activities are prepared before. So the commission will be in a session in October. So the decisions that will be taken in November 2025 will not be part of the report of 2025.
No, we need to stop it.
So I agree with you that there are some things in the charter that should be revisited, but what you have forgotten is that we have Article 68 in the charter, which is an article concerning amendments of different articles of the charters. And
She's been going on for some time, right?
Any review, any amendment of any article of the charter.
Commissioner Maya, we will need you to wrap up, please, so that other people can also make an intervention. Commissioner Maya, we'll need you to wrap up, please, so that other people can intervene.
Okay. I wanted to say there has been something that we did not speak about, Article 68, where any amendment, any review can be done by a state through writing to the secretary. And it is the Conference of Head of States that can decide on this. So I think that all the states would be advised and informed that there will be an amendment to this and that article.
Yeah. Can you close the
So
mic?
there is a procedure of the review of any article of the charter. So when we read Article 68, we have the provision about any amendment and any review. So I think there is a possibility for the civil society to know how to engage in case they need any amendment.
Why can't the Commission do it?
Thank you, Commissioner Maya. We've taken note of your intervention. Thank you so much. We will move now to take another intervention from Dr. Ruth. You can have the floor.
Thank you so much. Thank you so much. Can you hear me well?
Yes, we can. Please proceed.
Thank you. Thank you, ISLA, for organizing this session, and thank you for having sustained intervention and advocacy on this issue. I just have a few reflections, and I want to begin by introducing myself. My name is Dr. Ruth Mekura. I'm a human rights lawyer and a researcher, a social legal researcher, and I've worked for about 15 years on violence against women and women's rights broadly on the continent. And one of my reflections is that I actually support, the reason why I support the call to pause and analyze the convention first before we rush into ratification, and why I think that it's important for civil society and different actors not to invest the limited resources we have into advocating for ratification before we pause and reflect on whether this convention brings us forward or takes us back. The first reason is that on the continent, if we pause right now and don't rush into advocacy for ratification, there's actually no normative gap on state obligations to end violence against women. And I'm speaking this as an authority. I introduce myself because this is actually my field of expertise. Article 4 of the Maputo Protocol has robustly established state obligations when it comes to ending violence against women and girls. I have published extensively on this. My most recent article, which I can share, was published by the University of Pretoria, the Pulp Center. It's a commentary on the Maputo Protocol. And I specifically wrote on Article 4 on ending violence against women. And if you understand this provision, you will know that there's no urgency, there's no normative gap that suddenly needs to be closed, that we need to rush and get our governments to ratify this convention so that women and girls can be protected from violence. There really isn't. And I'm speaking comparatively, even when we look at what the Maputo Protocol Article 4 means in light of the UN global standards on violence against women, the Inter-American, the European, other comparative regional instruments that exist. So there is no gap. And for me, this means that we have an opportunity to stop the rush to ratify, because women and girls are still protected from all forms of violence against women, including femicide, including economic violence and technology-facilitated violence, because these are the words that have been introduced in the new convention, which I think are making some of us feel like we need to rush and ratify because otherwise we are not protected from femicide. No, any of us can bring cases before the commission, before the court, on cases of all forms of violence against women, including femicide, under the current normative framework. So I think the gap on implementation is such a critical one that we need to unpack and see how the convention can truly make things stronger. I don't think that we lose anything by saying, let us take a moment to pause and reflect. And if we say that we just want to run and ratify and then fix the implementation issues later, that means that we are not taking the lessons that we've learned over the decades of the African human rights system existing. I think this is really a moment when we can strengthen the African human rights system by identifying what the gaps are and ways that we can strengthen and fix them. So in many meetings that I've sat about this convention, I really do hear people saying, let's just move along because we have it now. We've never really had a convention on violence against women. It's a standalone instrument on violence against women. And so it has closed the gap. Let's just move forward. That's factually incorrect, right? We do have very robust regional standards on violence against women. We have decisions from the African Commission itself that have expanded our understanding on the scope and the content of state obligations to end violence against women. So we are not beginning from scratch. We have an evolved legal, normative standard that consists both of the frameworks, the instruments, and jurisprudence that is continuing to grow, right? So I think it's important to understand that context when we think about what solutions, or rather what strategies we should be adopting next. The second reflection I wanted to say quickly is that when we think about the critiques of the Commission, for example, some of the gaps around Article 59 and why it's not working, I don't think this means that we are not for the Commission, right? So as civil society organizations, we're actually in defense of the Commission. So if you look at the work of CEVAWG, this is a coalition of civil society organizations that are investing time and resources to defend the independence of the Commission. If you look at the Arusha initiative, it's a collective of CSOs, and we are saying we want to make sure the best candidates make it to the Commission so that it can function well. So as civil society, we are for the Commission, we are defending the Commission because it's our Commission, we don't have another body like this. It is the most accessible supervisory body that we have for our human rights system, and we want it to thrive. So it's just, I think the reflection I'm having is many times there's a misconception that it's that a critique of the current situation is saying that we are not, for the Commission, but it's to say this is actually coming from a place of wanting to defend and strengthen the mechanism. Thank you.
Cool. Professor Manju, I don't see you anymore.
Yeah.
Cool. Okay, Dr. Faye, please come.
Good afternoon, and thank you so much for organizing this webinar. I was saying to you, my apologies. I had some personal issues, that's why I've not been able to get back to you. But I said to myself, I'm not going to miss this webinar. Now there are a few things which I wanted to comment. But let me first of all address what Dr. Ruth has just said. That even though these normative instruments, other normative instruments are there, and they can fill in. So let's take a pause and reflect on what we have. Name me any instrument, any human rights instrument. I can show you imperfections in all of them. Anyone. So the more you pause and reflect, there's no perfect international, regional, or sub-regional instrument, human rights instrument. Name me anyone, and I can go through it and I can show you all the gaps. So whilst we are pausing and reflecting for signing and ratification, I'm asking myself, aren't we doing slightly more harm going forward? Because I say to myself, how many countries will be, by the time we get the required number of ratifications so that it is adopted eventually? I'm asking myself, I don't know. Yeah. So even though we are pausing to reflect, I don't see, I completely agree with Commissioner Maya. We can still go ahead, as the Latin phrase, pari passu, for signing and ratification, whilst we are doing something about implementation. Now, I mean, myself and yourself have had this conversation a few times. I seriously believe the African Commission is the right organization for implementation. Having said that, I have very, very deep reservations about the African Commission. And I am very happy that you keep going back to 2006, 2007. Those were the times when people like Sanji Moynihan was there. People with backbone. People who can stand up for what they believe is human rights on the continent. I was at the Commission sometime last week and having the conversations with colleagues and all of that, and even when I was at the session the last time. And you get this feeling that we have a different crop of commissioners who don't have the backbone that what we used to work. When I work for somebody, when we work for people like Sanji, Pansi Tlakula, these are people who fundamentally believe in what they are doing. And so the challenge we have with the African human rights system, and particularly with the African Commission right now, is not as a commission as a whole. It's a crop of people we have there. Seriously, if we keep this crop of people there, in my view, a lot of things will go wrong. And we know, you know the historicity of Article 59. We know where it came from. We know at one point in time that the policy organs of the African Union wanted to shut the African Commission down. We all campaigned to say, no, you cannot do that. And so going forward, I seriously believe that we need to sensitize, as Commissioner Maya says, this is a public relations and advocacy issue. We need to sensitize ourselves and our CSOs. I'm even saying to myself, why can't we, I mean, I'm looking at many of the people who are on this call, many of the big NGOs are not there, the people, many of them who shout. And you must remember why the backstory to how the African Commission got this thing to monitor and to implement and all of that. They campaigned for it. We know that they don't have the resources, the manpower, and all of that. But I'm saying to myself, probably, are we able to go back and say to the African Union, set up a different type of monitoring body? Probably we're not able to say that. So right now, going forward, I think we need some serious public relations campaign to sensitize our community, to sensitize our publics, to sensitize the CSO on what we have in our hand. Radio broadcast, television broadcast, it should not be impossible for us to convene an Al Jazeera, a CNN, on some of these issues, where we debate. Article 59, you mentioned that countries don't like to be embarrassed. We are not out to embarrass the African Union or the African Commission, but to bring out some of the shortcomings to show that things are not as they are. When I worked for them, from 2005 going forward, we just tell litigants that this is what is happening. Things have changed. And they have decided to reinterpret things differently, and I don't know why. I go to the Commission and I see a different creature. I don't understand it myself, and I think the only way to address it is to do serious public relations exercise so that we go back to tabula rasa. We go back to what it used to be, serving the African people, which is not doing currently.
Thank you so much.
Thank you, Professor Manju. Thank you, Dr. Faye.
Thanks, Sibongile and May. And thank you very much to ISLA for organizing this. I want to agree with Dr. Ruth Nakura on many of the points she's raised. And I say this from an insider perspective, where we have to stop and pause, because this cycle of ratifications is not giving people a chance to, first of all, understand the process and understand the substance of this convention. The process is, we don't have a document that sets out process so everyone's aware of it. I think that's a shortcoming of the whole, of this process around the convention. It was very rushed, and I say this from someone who was part of that. But there were many other issues. The substance issue, I think the challenge for me was, the irony is the heads of states adopted this convention in February of this year, and it was still in draft form. When Djibouti signed it, it was still in draft form, because the legal department of the AU was still going through to finesse it and sort out the interpretation issues, etc. So the final version only got shared, well, globally, not only regionally, in June of this year. Now we are at the end of July. How many people know what's the substance of it and the implications of some of the substance? How many people are questioning process? So to, you know, the two speakers that we had, Maya and Faye, in as much as I can understand their insider perspective, either being a commissioner or having worked in the AU, the challenge is when we allow for these processes and substance issues to be put on a back burner to say, let's go ahead, let's get the ratification, let's get it. Unfortunately, it becomes a pattern of accepting a glass half full. And I do think, you know, after the Maputo Protocol and some of the challenges, it's a good instrument, but some of the challenges in implementation, etc., I think we need to pause. We need to do what ISLA is doing, is the educative process and getting feedback from people on process and substance. The other issue that I think Commissioner Maya raised was about Article 14 of this convention, you know, Article 59, etc. I don't think we can separate them and deal with them as freestanding individual items. Everything has a coherence that needs a holistic interpretation. And here we have ISLA and its cohort of lawyers wanting to strengthen and use the African human rights system, hitting this challenge of Article 59 and the interpretation and the challenges that they face. So we cannot say, let's deal with Article 14 separately, let's deal with Article 59. There is a linkage. And I'm so glad that ISLA is bringing the linkage and making it visible for many people who may not know what the linkage is. So I see it as a symbiotic relationship that we need to be talking about. There are structural problems that need to be addressed in the way the Commission is doing its work. If the structural problem also includes the choice of commissioners and how they work, are the other organs weakening the Commission and the court, etc.? These are issues that we need to talk about, because this is a new instrument that we want to address a widespread and pervasive human rights violation issue on the continent and globally, and we should be asking these questions. So thank you to ISLA again and to all the previous speakers.
Thank you so much. Thank you so much, Prof. Ike, you can have the floor.
Yeah, thank you so much, and thanks colleagues for organizing. I align myself a lot with Dr. Nakura's comment, and I think the most important is the fact that, so the question is, what was the actual objective that this convention was adopted to serve, and why was it so rushed? And why did we have a charade of having a draft convention adopted and all what has happened? It's clear to me, and I'm not saying this from any insider knowledge, that there seems to have been other purposes of other than ending violence against women and girls that we are pursued in the rush to get this out and to get it out when it was before the elections and all of that. That being said, I agree that the protections, like the experts in the room have said, the protections we have in the Maputo Protocol are great, and we have access to the court for the countries that have made the Article 36 declaration, and we can still protect the rights of women and girls. Now, if the concern around ratification, so the pause and reflect, I think it makes sense on the civil society standpoint, to the extent that we control how states think about ratification. But ratification ultimately is still a state affair, and they've done really poorly in terms of ratifying the human rights instruments we have on the continent. Now, if any state is so eager to ratify something, we've got to point them to the things they need to ratify, and in that thinking, this would not be a priority. We need them to ratify the protocol of charter to the court. For those who have not ratified that protocol, we need them to make the Article 34.6 declaration. We need to broaden the space for access to justice. So the question here is not necessarily, like I said, we don't control ratification, right? States do control ratification. And I think the alarm that is going out is, on the one hand, it doesn't make sense what Article 14 is, knowing the context. But secondly, if this is the best you could come out with in terms of a convention that should have extended protections in the Maputo Protocol, and it's not looking like it, then we should prioritize these other instruments that enhance access to justice, including for women and girls, in terms of state action and ratification. And there's a broader challenge around the leadership of the mechanisms and how that has, listening to the historical perspective of some people around the room. And, Dr. Nakira also made a initiative. And I think it's important that because when people get into these mechanisms, they are there for at least 10 years and some 12 years. And so it's not easy to change, the list of or the individuals who run these mechanisms. And we are not saying that those who are there have not done some good work. But what we are saying is that there were times when we could actually let the defense of these mechanisms to the members of the mechanism. And so my point is that one thing I believe we are taking out from here is the fact that in terms of ratification, this document is not a priority. There are other things that if all states can make the Article 34.6 declaration, then we may not even have a challenge here, because the options we laid out could have been easy to just send cases to the African court, right? And the Article 34, the Article 59 issue is a foundational issue. It actually cannot be separated. It's a foundational issue whenever there's an issue around access to justice. So I feel like as we decide to reflect, pause and reflect, I think prioritization also is something we need to think about. Thank you.
Thank you so much, Ike.
Do we have other questions? I do not see them. Do we have questions from the other platforms? Okay, good. So let's go back because now we are kind of moving to the close. And may former Commissioner Maya raised the issue of, Article 14 deals with other things. Of course, our focus is on the communications procedure, because we litigate. We don't work on state reporting.
Show the reporting.
And state reporting
the commission can make, their recommendations at the end of the state report, but it's not an accountability. Well, it's a form of an accountability kind of measure, but it does not give redress, to victims of rights, violations. It's an assessment of the country's kind of human rights situation based on what they are. But what are the current challenges, of the African system as a monitoring body? Because I think when we started, we said the challenge with Article 14, it's that it is a reinstatement of existing, challenges. It is true that the African Union keeps on giving it this implementation and monitoring. We see it on the Convention of the Rights of People with Disabilities. It's been given to the African Commission. And that's also part of why we are saying these people are not really serious about implementation because they don't want to close the implementation gap. They keep on consigning conventions to a body that they know is not able to hold them to account. But let's just address the monitoring issue. Okay,
yeah. So just like Commissioner Mai has mentioned with Article 62 of the African Charter, states have to submit periodic reports biannually on the legislative and other measures that they've adopted, really. Same thing applies to the CEVAWG Convention in Article 14. However, when it comes to compliance with the reporting obligations, it's extremely poor. Just looking at data and just looking at statistics, basically, when it comes to states' compliance with the reporting, requirements, when we look at the African Charter and the reporting to the African Charter on the African Charter to the African Commission, as of October 2024, that's around the 81st session of the African Commission, we have that only 10 states were fully up to date with their reporting obligations. And at the same time, Amnesty International have published a report in 2020 stating that only 11% member states were up to date, with about 48 having 3 or more overdue reports. And 6 states have never submitted even the initial report, really, since they ratified. We have countries, for example, that during the 81st session, Burkina Faso, Angola, Ethiopia, and others, they were submitting reports that covered multi-year span from 2015 to 2021 or even longer. So it really kind of undermines the purpose of the reporting, the biannual reporting. And the same challenge exists when it comes to the Maputo Protocol and the requirement of submitting reports under Article 26. Out of the 42 states that have ratified the Maputo Protocol, only 27 states, which accounts to 64%, had not submitted their initial report yet. And yeah, this has really a lot of implications, right? When it comes to the overall objective of the monitoring mechanism through the reports that are submitted. You find that the concluding observations that are given to states tend to be generic, right? And they lack concrete recommendations because they're speaking to issues that span over years and years. And it really limits the utility to civil society organizations, litigators, or even when it comes to national reforms through policy changes and laws. And then there's also a widespread reporting fatigue when it comes to member states reporting to several conventions that they are part of. So adopting the CEVAWG Convention, it also introduces another layer, right, of a reporting obligation without really addressing the systematic weaknesses that we have in terms of compliance with the reporting requirement, the follow-up, etc. Yeah, so this just gives an overview of where we stand when it comes to the reporting procedure. Yeah.
So once again, Article 14 is an entrenchment of existing problems. And that's why we cannot see it as new. Because as you go through it, we have seen this. This is about complementarity between the Commission and the court. There's a problem. This about 34.6, there is a problem. This is about state reporting, so monitoring, there is a problem. This is about the communications procedure. We have an implementation gap. And Article 14 presents an implementation gap because we haven't gone back to sort out all of those problems. But what I would like to say as we kind of wrap up and kind of give over to you to say your closing remarks. In this convention, what we wanted to highlight was what the implementation gap is. And I think with the interventions that have been made, especially people who have got insider knowledge, and this is what continues to happen in all of these conversations, especially the people who say, let's go forward with the ratification. There has never been a dispute that there is an implementation gap. The implementation gap exists. Where we may differ is whether we pause to analyze or whether we continue with the ratification and we sort it out later. We have demonstrated that this is a problem that has existed for decades. We have not been able to sort it out. Yeah?
Yeah.
In all of this time. So when we say we are going to sort it out later, what are we going to do? Because in order to move forward, at the very least, the Commission could have said what they were going to do. What I also find interesting is the work that is given to civil society. So for example, around Article 8, around the amendment kind of the Charter, I have never understood it why it has to be us that ask the Commission to do Article 60, why it has to be us again who ask them to get member states to do the Article 68. My understanding of accountability mechanism and the link with access to justice is that they have to fight to be able to do the work that they are set up to do, that they have the primary responsibility. And for as long as we sit with an accountability mechanism that says our hands are tied from protecting human rights. You made the point about how this convention has Article 12, which is about access to justice. It talks about access to justice for victims. And then 2 provisions later under Article 14, you are entrenching a system that denies them access to justice. And then finally, we are going to have to make a decision as civil society in this continent about whether we are taking our rights seriously or not. Legal academics have analyzed the problem with the African human rights system. For me, the fact that the African Commission can be given implementation and monitoring whilst we were in conversation with them about Article 59 tells us that we are actually not being heard. But what is even more scary about the rejection of the pause to analyze and what we will use, we will lose if we don't move ahead with ratification. It is simply that even the provisions that are there in the convention have not been analyzed. So if you ask a person to go and look at what Article 5 that speaks to access to justice, whether these are the normative standards, that deals with state obligations, whether these are the normative standards for state obligations. So people who I have heard pushing for ratification have mostly been chanting slogans, right, about how this is good for us, why this is an important document. But we haven't had the opportunity to go through each section to say, yes, this is great. There is a crimes against humanity kind of convention that's being discussed, negotiated right now. People have been crisscrossing the world, different meetings in different countries to discuss various provisions. A convention can never be a surprise to civil society. We cannot be sitting with a convention and we are trying to figure it out. And I think, for me, this is what respect for African civil society or citizens, to say, yes, we understand something went wrong. We did not have meaningful consultations. The process was not transparent, but this is where we are with it. It has been adopted. We will give you the opportunity to engage and talk about this convention. The push for ratification, at least to me, feels like work with us to bury our shame, right? So that we don't analyze, we don't look at process, we don't look at substance. It's like this herd mentality, let us all go forward. What are we going forward with when we are sitting with a convention that does not have a travaux préparatoire? We know this is important for interpretation. We are saying, this is the work that we do, this is the work that we have done, and we have seen the violence that it does to human rights protection when you do not have an implementation mechanism that prioritizes access to justice. So where are we going with these standards? We look at conventions as a legal instrument that sets out state obligations and rights for victims. Instead of these slogans, why are we not talking about these rights? Why don't we allow this conversation to happen? Why is it that what we are getting are posters and slogans that says, this is the best that we got? Why are we being threatened with our rights? That this is going to do us harm. How is it going to do us harm? Why is the harm less than going ahead with something that many people are saying, we haven't had the time to look at it? So that's how I am closing. And how are you closing?
Okay. You've raised the bar, you know, when it comes to closing. But I think in closing, for me, the closing remarks that really reflect how I think about this convention and how we engage with it is that when we engage with the CEVAWG Convention and its proposed implementation framework, we really need to do so with both clarity and courage. It's not enough really for a treaty to exist. It must be fit for purpose. A convention that promises justice but entrusts its enforcement to mechanisms that are structurally incapable of delivering it risks becoming a tool of symbolic progress rather than transformative change. And it would be a missed opportunity for us who engage in these issues across the continent. The concerns that we've raised around Article 14 and the reliance on the African Commission's current interpretation of Article 59.1, these are not really marginal technicalities. They sit, you know, at the heart of access to justice, transparency, and accountability. They are non-negotiable pillars of any meaningful protection of the rights of women and girls in Africa. Therefore, I really believe that we must resist the pressure to move forward and fix it later. We must pause, interrogate, and if necessary, reimagine the structures we are building in the name of justice. We need to honor the lived experiences of those this convention seeks to serve by ensuring that the tools we adopt are not only legally binding, but also institutionally sound, publicly accessible, and politically committed to human dignity. We owe nothing less to African women and girls, and this is how I'm closing. Thank you.
Thank you very much for staying this long with us. We really appreciated your time, and we hope you understand what the implementation gap is. Have a wonderful afternoon. Thank you very much.